Committee will come to order. Thank you for your patience. We welcome our second panel, Michelle Simon, Ms. Tracy Jennison, Professor Alhaig, Professor Diamond, Mr. Richard Doyle, Ms. Nina Simona, Chair from Michigan, and the Attorney General of Utah, Mark Shurtleff. We're happy to start off with the Attorney General, who has, among other things, and I don't know how he finds time, written a book of that I think is going to be very well received, not only on the Hill, but in government as well. And we'd like, is Mr. Chaffetz here? We'd like to recognize him for any further introductions.
Thank you, Mr. Chairman. I appreciate it. It's an honor to have all of the panel here, but in particular the Attorney General from the great state of Utah. Mark Shurtleff was reelected as the Utah Attorney General in November of 2008 with a strong 70% of the vote. Is now serving as the first three-term Attorney General in the history of Utah. In his first 8 years in office, the number of meth labs in Utah was reduced by 98%, and he's talked to thousands of students and parents about the dangers of drugs and led an effort to obtain millions of dollars in funding in education and rehabilitation. Attorney General Shurtleff was born and raised in Utah, graduated from Brigham Young University and the University of Utah College of Law. He served in the U.S. Navy Judge Advocate General Corps as an officer and attorney from 1985 to 1990. Mr. Shurtleff returned to Utah to serve as the Assistant Attorney General from 1993 to 1997. He is the past chairman of the Conference of Western Attorneys General, and he served in the Executive Committee for the National Association of Attorneys General. He also served on the board of directors of several national and local organizations. He's the author of Am I Not a Man? The Dred Scott Story, a historical novel about the man behind the landmark legal case. And most importantly, he and his wife, Melissa, have been married for 27 years and the proud parents of 5 children and 2 grandchildren. And we're an honor to have him here today, and I appreciate the chairman for allowing me to say a few words. Thank you.
Welcome.
Thank you very much. Congressman Chaffetz, thank you. Good friend. We worked together when he was Chief of Staff for Governor Huntsman, now Ambassador Huntsman. And it's good to be here. Mr. Chairman, members of the committee, thank you very much for the invitation. It took me 7 years, Mr. Chairman, to write that book, so start writing yours now. It's an honor to testify, truly. I really appreciate this invitation to talk about things that are so important to my heart, including the United States Constitution, states' rights, the role of Congress vis-a-vis states, and the protection of the public. Utah knows a thing or two about the 21st Amendment. You may not know that it was Utah, after all, that was the 36th, the deciding state to ratify the 21st Amendment. The reasons why Utah and this nation endorsed the 21st Amendment remain as relevant today in 2010 as they did back in 1933 when it was ratified by Utah. The relevance of the 21st Amendment stems from the undisputable fact that alcohol, or as the Constitution calls it, intoxicating liquor, is a unique product, both constitutionally and physically. Alcohol clearly isn't for everyone. We know this. It's age-restricted for good reason. Science every day is coming out with more information as to why youth access to alcohol and the harm that alcohol causes to the developing brain. It causes harm to society. The costs to states and local communities are extensive. So states do have a compelling interest in using their police power and all their regulatory tools to mitigate those costs. The people of Salt Lake City feel differently about alcohol than the people in Detroit. That's the beauty of the American system. As a historian, I'll tell you that the The part that the federal government intervention in alcohol policy has not been really successful, from whether it's the Whiskey Rebellion or the failure of prohibition. The 21st Amendment and the state-based regulation of alcohol has been a stunning success these many years. While there's still too much misuse and abuse, no doubt, our problems pale in comparison to those of other countries like the United Kingdom. Every state has tools to regulate this industry. They cannot be slowly whittled away in court, which is what's happening and why we're concerned. Now, Utah takes alcohol regulation very, very seriously. We are a control state, as you may know. The state controls the sale of distilled spirits, certain malt beverage products. Any profits go to the state coffers to offset the costs of government. We have other alcohol laws not found in other states. That's a function of state-based regulation that we should not be hauled into federal court to defend our efforts to protect our citizens. Now, as the past chair many years for the Youth Access to Alcohol Committee of the National Association of Attorneys General, we worked very hard over the years to work to reduce underage drinking. We have collaborated and worked effectively with industry in these efforts to keep alcohol out of the hands of those who should not have it. But concerns over states' rights is something that unites all of us as attorneys general. From liberal to conservative, Republicans and Democrats, alcohol regulation under the 21st Amendment is a state rights on steroids, you may say. Over 35 different lawsuits in 27 states challenging the right of the state to regulate alcohol has been filed since that Gramhold decision in 2005. Now, there's been more uncertainty due to that decision by creative lawyers, who I'm sure we'll hear from later. In a close 5-4 vote, as you know, the court believed that the Michigan system impermissibly harmed a poor artisan out of state winery. Now, fast forward 5 years later and ask, where are the states in trying to understand what this decision meant? The answer is the legal waters are muddier. They're not clearer. We're all over the place in this country. And now, instead of a small, aggrieved winery struggling to get to market, we now have Anheuser-Busch InBev, $84 billion global company, using the same theory in Granholm to say they are being discriminated against in Illinois. Last I checked, AB InBev beer was everywhere. How they compare to a small winery or similarly situated is beyond me. As you'll hear from the regulator from Michigan, Michigan has been hauled into federal court on this very issue of retailer shipping. Texas and New York were sued too. Michigan lost at the district court. Texas and New York won at the 5th and 2nd Circuits. So what am I supposed to tell the legislature of the state of Utah? Go with Texas and New York ruling, or race to the bottom and abandon regulation to be safe from a Michigan or a Washington decision, where the circuit court, the 9th Circuit, overturned the judge's ruling and only left one regulation they said was impermissible, and yet the judge still awarded over $1 million in attorney fees, the cost of the taxpayer state of Washington. We have lawsuits that twist the Granholm decision from treating small business differently than big business. This needs to be resolved, and so we're coming to you. We're asking for your help. We need to have you clarify this. Now it's true that there were 40 AGs who signed a letter, but that was before the bill was passed. The letter is there. The wording is clear. They didn't say they endorsed this bill, but they're asking for help the same way we are in this bill, and that bill provides it. We need you to clarify. You can do that. We beg of you to say what is meant by the Commerce Clause, the dormant Commerce Clause, so that when the Supreme Court gets this again, Congress has spoken, and they're going to receive that information. The revised CARE Act would capture the essence of Granholm's decision by preventing wanton discrimination against out-of-state suppliers. It'll also provide clarity to state legislators and would strengthen states to keep the ability to regulate alcohol according to local customs. So thank you very much for the opportunity to be heard on this.
Thank you for starting us off. Our next witness has been before us before. She's the chair of the Liquor Control Commission of Michigan, a lawyer, former prosecutor, and has put in a great deal of time working to make sure that Michigan has a safe and effective alcohol marketplace. Welcome again, Ms. Simona.
Thank you, Mr. Chairman. Thank you very much to the committee for listening to us. Thank you to all of you that have taken the time and the opportunity to recognize how important this issue is to the state of Michigan and to all states, actually, in regards to the 21st Amendment, which gave plenary power to the states to regulate alcohol. The state of Michigan was the very first state in 1933 that ratified that 21st Amendment. Like Utah, we saw the need, we understood the need for it, and the recognition that the state has to intervene. This is not milk we're talking about here. This is a product that can be enjoyed, that's very beneficial and lucrative to the state of Michigan, that can also be in the wrong hands at the wrong time with kids that are minors, with overconsumption of alcohol, and with doing things with alcohol, mixing it in a way that can be lethal. We understand that. I understand that as the only regulator sitting up here on the panel. Now, Ranking Member Smith asked, how many lawsuits are we talking about here? 25 to count and still going. 2 of them have been within the last 7 years with the state of Michigan. That's the Granholm case. That's my boss, Governor Granholm, who sends her best to all of you. That started it, and 24 lawsuits later that came after that. That was a lawsuit that dealt with wineries. Why can't wineries be treated the same outstate as in-state? We modified our state laws so that we can do that and created a permit system because of that. Because it went all the way to the Supreme Court in a very narrow 5-4 decision was in favor of the wineries. Then several years later, we have a case of Siesta Village. This time, it's not about wineries, it's about retailers that say an outstate retailer should be able to sell and ship alcohol into the state of Michigan to anyone that they want to at any time. When we regulate our own retailers, and we have 17,000 retailers in the state of Michigan, and certainly you know that, Mr. Chairman, that they're very active. They're small independent businesses as well as large chain stores throughout the state of Michigan. We make these retailers have to go through server training classes so that they understand they have to ask for ID. They have to look and determine if a person's intoxicated, if it's an on-premise licensee, to determine when they can cut them off. They have to go through violations and penalties up to being suspended and or revoke their license. These are all these retailers that are within my state that we regulate to ensure that they follow the laws of the state of Michigan and the rules of the Michigan Liquor Control Commission. But Siesta Village would have you, in that lawsuit, say a retailer in California, Florida, Ohio, Indiana, anywhere else should be able to sell this product and ship it to a home, not knowing is that person of age to receive it, not having any identification processes. And this thought about the UPS system or delivery system checking for ID is just not one that works. What if they don't? What power do I have over that licensee that's not within the state of Michigan? Because my 17,000 retailers that are struggling every single day, but we are hammering at them and on their back to make sure that they follow the rules and understand this is a commodity that is enjoyable but can be very dangerous. Understand that the Liquor Control Commission means business. And so when we talk about these cases, I talk to you as a regulator. I'm also a lawyer. I'm also a former prosecutor. I understand what happens when you abuse this product. And I understand as a regulator what my role is to ensure that that doesn't happen. These lawsuits, Mr. Smith, have cost millions of dollars to the state of Michigan. Well, not one, but 2 lawsuits. With Siesta Village, we in fact had to tell our independent retailers that they cannot deliver to a client or a customer of theirs any of the products, that they must come in, not just purchase them, but pick them up at that time. As a result of that lawsuit, we didn't want to continue incurring additional millions of dollars and taking it up to a higher court. That's why it is so essential for Congress to act on this, so that this silence does not lead to all these ambiguous rulings across this great country of ours. The 21st Amendment and Commerce Clause has given us the power for each state to regulate based on the fit and the need of that state. That's the beauty of it. It should not be a one-size-fits-all. The rules exist, and we are here to follow them. But I, as the regulator, surely know what's in the best interest of my state and those that are living in my state and consume this product in my state. That is my duty. And I ask for you, Mr. Chairman, and all of you as the committee members to please act on this bill. Thank you.
Thank you very much. The next witness is the chairman and CEO of Harpoon Brewery, a member of the Brewers Association and the Beer Institute, And we're glad to have you here, Mr. Doyle. You may proceed.
Thank you. Mr. Chairman and members of the committee, my name is Richard Doyle, and I'm the chairman, founder and CEO of the Harpoon Brewery. We operate breweries in Boston, Massachusetts, and Windsor, Vermont. On behalf of the Brewers Association, I appreciate the opportunity to speak today. I'm here to give you a small brewer's view of H.R. 5034. You are entrusted to make the rules, and I want to provide you with my perspective on what it would be like to try to successfully play by those rules if H.R. 5034 is enacted. The wholesale or middle tier of the three-tier system of beer distribution is very important to small brewers. We do not have the scale to establish our own distribution network and need wholesalers to reach markets, particularly in other states. A successful and vibrant middle tier is vital to the interest of small brewers and our consumers. The current system has served the public well for the last 77 years. There is a delicate balance between state-based regulation that reflects the needs of individual states and a federal role to protect interstate commerce. Passage of H.R. 5034, even in its amended form, risks exposing that delicate balance to unintended consequences. Our brewery sells beer in 25 states. The wholesalers we sell to typically do business in only one state. State franchise laws with the stated goal of protecting wholesalers from dominant large brewers are also used to dictate the terms of trade between small brewers and wholesalers. I have worked through franchise agreements mandated by state laws with dozens of wholesalers, and we've developed beneficial relationships and even friendships. But those negotiations are always tough because state laws provide wholesalers with strong leverage. We are always the away team, playing in a state system that favors the home team wholesalers. H.R. 5034 would undeniably make that situation worse. Not only would we be playing away, but the state-based referee would not have any concern about being tempered by federal oversight. Small brewers are also concerned about the diminution of federal role in another area. State label regulation is a good practical example of how subtle discrimination could work. If we are required to have 25 different labels for the 25 states where Harpoon sells beer, that cost would be prohibitive. We would not be able to manage the inventory and keep our beer fresh. We would need to sell in fewer states, and our brewery would, and our customers would be worse off. Small brewers also tend to make many different styles of beer, which only compounds any state-based labeling requirements. This is not a hypothetical situation. In the last 2 years, wholesalers have lobbied successfully in Michigan and New York for unique labeling requirements. The New York law was struck down as a violation of the Commerce Clause, and the Michigan legislation had to be amended to exempt small brewers. Under H.R. 5034, those laws could stand, and we would be at a great disadvantage in both states. We appreciate the threat that wholesalers feel to their businesses from a change in the status quo and more power flowing to large retailers. However, we do not think that solving a problem for wholesalers by creating a problem for brewers makes sense. It is very unfortunate that after more than a year of discussion between wholesalers and suppliers, we could not reach a compromise. Brewers large and small worked very hard and in good faith to reach a compromise, despite the fact there was nothing we would gain from the legislation. Each version of H.R. 5034 that we have seen this year is detrimental to small brewers in three aspects. First, it repeals the Wilson Act of 1890, which prohibits discrimination against out-of-state producers and products. Second, the new language in H.R. 5034 encourages states to adopt laws that discriminate in subtle ways. Finally, the bill diminishes the federal role in regulating interstate commerce. As a small brewer in Massachusetts, I do not have the resources to fight every discriminatory state statute and regulation that restricts my ability to compete and grow in other states. I spend thousands of dollars every year attempting to comply with state laws, many of which were clearly intended to protect local economic interests. I make great beers, and I want to sell them to your constituents. Great principles of limited government and free enterprise are often ignored when local economic interests and legal authority are combined with no checks and balances. The federal courts provide that constitutional check, and they have exercised it responsibly in decisions concerning alcoholic beverages. The Supreme Court and appellate courts have overturned a relative handful of unconstitutional state laws. Those policies clearly favored state and local interests or reduced competition in ways that have nothing to do with temperance or public safety. In closing, I respectfully urge the committee to refrain from reporting H.R. 5034. Our industry is already adequately regulated at the federal and state level. No credible group or industry organization is attempting to deregulate the sale and consumption of beer, wine, and spirits. Thank you very much, Mr. Chairman.
You're welcome. Professor Stephen Diamond, is professor from the University of Miami. He has both a PhD and JD from Harvard University. Is co-chair of the American Bar Association Committee on Beverage Alcohol Practice. We welcome you here this afternoon, sir.
Thank you for the opportunity to appear before you. I would like very briefly to make several observations about H.R. 5034, observations which I have developed at greater length in my written submission. The Supreme Court has made it unquestionably clear that the final authority on the relationship between state alcoholic beverage law and the Dormant Commerce Clause is Congress. Congress can protect state alcoholic beverage laws to the extent it sees fit. From 1880 onward, Congress did attempt to do so, but until 1917, when the Supreme Court upheld the Webb-Kenyon Act, its efforts to support and protect state alcoholic beverage regulation were constantly frustrated by the court. For decades after repeal, Congress had no need to speak further to maintain its support of state alcoholic beverage laws, as the Supreme Court interpreted the 21st Amendment to protect those laws from challenge. In Granholm, however, the Supreme Court limited the protective effect of the 21st Amendment and of the Webb-Kenyon Act, holding that the latter was limited by the Wilson Act. This interpretation of Webb-Kenyon is at odds with the history of the enactment. An analog of the Wilson Act, proposed to be included in the Webb-Kenyon Act, had been withdrawn during consideration of the bill as inconsistent with what was ultimately enacted. That is, the Wilson Act was explicitly detached from the Webb-Kenyon Act. There was, moreover, no congressional discussion during the Webb-Kenyon debates about the importance of preventing discrimination against producers. There was, on the other hand, lots of talk about the need to shield state alcoholic beverage regulation so that it might be effective. The Court's interpretation of the Webb-Kenyon Act is, of course, not binding on Congress. Congress can now do what it thinks right. Misunderstandings of Granholm are rampant. The Court did not declare that interstate commerce in alcoholic beverages could not be burdened. The Dormant Commerce Clause does not do that for any products. The Court held only that the 21st Amendment and the Webb-Kenyon Act, as the Court interpreted it, did not protect intentional or facial discrimination against out-of-state producers. Contrary to some claims that have been made, the Dormant Commerce Clause, as articulated and as applied, is not exactly clear and unequivocal. In the so-called canonical expression of Dormant Commerce Clause doctrine, in the Brown-Forman decision, the Court immediately concedes that it has proved impossible to apply the doctrine consistently. This is not a bad thing. The Court has, in effect, cautiously refrained from treating the Dormant Commerce Clause as one-dimensional. It has looked to many factors in cases where it has held that no discrimination was demonstrated and that state laws should therefore be upheld. In Exxon v. Maryland, the Court rejected the claim that state law discriminated in favor of in-state retailers, declaring that the Dormant Commerce Clause protects interstate commerce, but not the business strategies of particular out-of-state sellers. In General Motors versus Tracy, the Court rejected an intentional discrimination claim because to accept it would threaten a highly regulated system of local utilities. In Kentucky v. Davis, the Court rejected a facial discrimination claim because the distinction was one which many or all states had made for many decades. H.R. 5034 is a modest step consistent with constitutional jurisprudence and respectful and protective of 75 years of state regulatory practices. The terms and conditions of distribution and sale of alcoholic beverages must be controlled by law and not left up to the desires of thirsty drinkers and profit-maximizing sellers. State alcoholic beverage regulation since repeal has attempted to constrain overselling and thus overconsumption and abuse. It has conversely attempted not to overregulate and thus stimulate illicit and therefore unregulated manufacture, distribution, and sale. It has aimed for moderation in regulation to achieve moderation in selling and moderation in consumption. This regulation has worked well. Congress should continue to support it. Thank you for your consideration.
Thank you. Also from Harvard is Professor Einar Elhaig, the Petrie Professor of Law at the Law School, and is testifying on behalf of the Beer Institute. He is a former clerk for Justice William Brennan and has taught previously at University of California, Berkeley, before coming to Harvard. Welcome this afternoon, sir.
Thank you, Chairman Conyers, Ranking Member Smith, and other members of the Judiciary Committee. I am, as the chairman said, Einar Elhaig, the Petrie Professor of Law at Harvard Law School, where I specialize in antitrust and statutory interpretation. I have been asked to present my views of the bill by the Beer Institute. Proponents of this bill argue that it is necessary to correct three problems: case conflicts, deregulation, and excessive litigation. But when I reviewed the cases, I found that none of those three concerns was well-founded. First, the alleged case conflicts largely reflected differences in case facts, or had been largely resolved by the courts through the common law process. Second, none of these cases actually resulted in deregulation. Third, because the courts have already clarified the issues and state legislatures have responded with legally sound laws, the initial stream of cases has dwindled to a trickle. Today, there appears to be only one active case in this arena that has not already been substantively resolved by the trial court. Even if those three concerns were justified, the proposed act would be a poor remedy for them. The act would greatly increase legal uncertainty and could be expected to spawn new legal conflict and litigation. For example, ambiguities in proposed Act Section 3A mean that courts might variously interpret it to either have no effect or to inversely preempt some or perhaps even all federal statutes that conflict with state alcohol regulation. Those ambiguities are likely to induce a spate of new lawsuits, only this time for the courts to figure out what Section 3A means. Further, decisions that interpreted Section 3A to inversely preempt federal statutes could allow state regulations that permit anti-competitive conduct contrary to federal antitrust policy. Section 3B would also create three new harmful exceptions to current dormant Commerce Clause doctrine. First, Section 3B would eliminate protection against state alcohol laws that have discriminatory effects on out-of-staters. This would allow states to discriminate by picking some seemingly neutral factor that has discriminatory effects. For example, the state could restrict sales by producers who sell a type of alcohol that's not made in state, or who meet a production threshold that no in-state producer meets. Section 3B would then require sustaining such laws unless an affirmative discriminatory intent could be proven, a test which is difficult to meet, is likely to generate new case conflicts, and would not address the core concern that discrimination prompted by indifference to harms in other states is just as undesirable. Second, Section 3B would allow discrimination in any form, even facial and intentional discrimination, against anyone who is not a producer. Thus, states could pass laws that explicitly discriminate against out-of-state consumers. That would seem contrary to Congress's strong pro-consumer policy. For example, states could adopt laws that require all producers to charge higher prices to out-of-state consumers, or that levy higher taxes on beer that will be sold to out-of-state consumers. Third, Section 3B would permit a state to directly regulate interstate commerce. For example, the proposed act will allow a state to enact a law that requires producers to affirm that they will not charge future prices in other states below the price charged in the first state. The Supreme Court held such price affirmation laws to be unconstitutional decades ago, observing that such laws interfered with the ability of those other states to regulate alcohol in ways that those states feel optimally advance their own 21st Amendment interests. These examples are not fantastic or theoretical. Rather, most come straight from the pages of existing judicial decisions. Thus, the danger posed by the proposed act is real and substantial. I am a big believer in states' rights, but those rights also include the right of states to be free from regulatory interference and discriminatory effects from other states. I also strongly believe in protecting children, but I see no reason why states cannot protect children with non-discriminatory laws, given the ample powers they already have under the 21st Amendment. So far as I can tell, the only two concrete issues that proponents point to is that current case law might threaten either laws requiring in-person consumer purchases or in-state residency requirements for retailers. In my view, the current case law has already evolved to fairly clearly sustain such laws. But if those are the real concerns, the solution would be a much more narrow bill, not a bill that creates vast new exceptions to the constitutional jurisprudence that protects states from discrimination and interference from other states. The Dormant Commerce Clause may seem like an obscure technical topic, but it is the constitutional jurisprudence that really united this nation into the world's greatest free trade area, preventing states from engaging in the sort of beggar-thy-neighbor protectionism that nations often use against each other. It is a vital part of what made America a great nation, and its principles should not be unnecessarily cast aside.
Thank you very much. Ms. Tracy Jensen from Kirkland and Ellis is testifying on behalf of the Wine Institute. She's litigated commerce clauses challenging state regulations, including the Granholm case in the Supreme Court. We welcome you this afternoon.
Thank you very much, Mr. Chairman. I am Tracy Jennison, and I will pretty much focus my remarks today on Mr. Delahunt's new language. I represent the Wine Institute, the Public Advocacy Association of California Wineries, which includes more than 1,000 wineries and affiliated businesses. Those wineries represent a vital sector of the United States economy. America's 6,700 wineries, the vast majority of which are family-owned farms, are responsible for more than $20 billion in sales in the United States and support more than 1 million jobs. The passage of H.R. 5034 will greatly imperil this dynamic agricultural industry. Today's wine distribution system is shaped like an hourglass, with thousands of producers at the top and millions of consumers at the bottom, but only a few wholesalers in between to distribute their products. United States wineries have an interest in even-handed, robust state regulation, permitting them to ship wine directly to consumers and retailers. But wholesalers have an interest in maintaining this exclusive grip on the bottleneck between alcohol producers, wine retailers, and consumers. H.R. 5034 is a piece of special interest legislation for the benefit of those wholesalers at the expense of retailers, producers, and consumers, literally everyone else. In particular, H.R. 5034 would harm millions of American consumers through reduced access to wines, increased prices, and reduced wine selection. And contrary to the rhetoric advanced by the wholesalers, 99% of these alcohol regulations are not vulnerable to federal challenge. The only state regulations that are truly vulnerable in court today are the anti-competitive ones that discriminate against out-of-state businesses or products. H.R. 5034, however, would eviscerate Commerce Clause challenges that protect the national union from states that discriminate in this way. And the Commerce Clause is the cornerstone of our national economic union. It applies to products and entities in the stream of commerce. It prevents state legislatures from affording in-state local market participants a competitive advantage or benefit without extending that privilege to out-of-state alcohol market participants. Through legislative efforts and when forced through litigation, states have cured this discrimination in two distinct ways. One, they have leveled up, which means they've extended the privilege to out-of-state interests as well. And from our standpoint, this is the best pro-consumer remedy. But states can also level down. If they want to take the privilege away from the in-staters, then they've also cured the discrimination there. In short, the Commerce Clause requires even-handedness, and so do federal statutes concerning alcohol regulations, such as the Wilson Act. When a state regulates even-handedly, or when it proves a legitimate interest that cannot be met through non-discriminatory means, it will survive Commerce Clause scrutiny. Since the Supreme Court's Granholm decision, courts regularly uphold state statutes when plaintiffs fail to meet their substantial burden of showing impermissible state discrimination. And we have recent examples of state statutes being upheld in such cases in the First, Seventh, and Ninth Federal Circuits. Discriminatory laws basically fall into several categories, and I'll mention a few here. Some state laws are facially discriminatory, like the Michigan statute. The Supreme Court struck that down in Granholm. Those statutes on their face apply to companies differently depending on where they are located. Other state laws appear to be geographically neutral, but they might require an in-state presence, like the New York statute in Granholm, or exempt a local product from a tax, such as the Bacchus case, or impose wine production caps that only in-state wineries can meet and out-of-state wineries can't. These statutes discriminate in purpose and effect. Under the Commerce Clause, such state statutes can be invalid for either of these reasons. H.R. 5034 would immunize these kind of alcohol statutes that do discriminate against out-of-state businesses in purpose and effect. Critically, the bill sweeps away the existing Commerce Clause standards and amends the Wilson Act to abolish even-handedness. H.R. 5034 really allows only one kind of limited challenge for one type of wine business. It preserves challenges against statutes that intentionally or facially discriminate against alcohol producers, but even as to producers, states could escape H.R. 5034 by discriminating against out-of-state products. A good example of this is a state like New York, where no Zinfandel is produced, could ban a sale and shipment of Zinfandel to New York residents. That would discriminate against California Zinfandel producers without incurring scrutiny under H.R. 5034. In place of the current legal standard that focuses on multiple factors to determine whether a state is discriminatory in purpose and effect, this bill calls for a narrow, intrusive inquiry into what state legislators intended. This is both highly speculative to prove and extremely difficult for courts to divine. As the Supreme Court in Bacchus pointed out, it could always be said that there was no intent to discriminate. Instead, state legislatures couch it as an effort to help in-state industries, an effort to insulate them. H.R. 5034 confines courts to a narrow, second-guessing-like probe into legislative intent. Commerce Clause cases are not common. In fact, there is only one of them left. And if you compare these Commerce Clause challenges to civil rights cases, in 2008 there were 32,000 civil rights challenges in federal court. Compared to the initial 25 here, down to one as we speak. When a state discriminates against out-of-state businesses without justification, Congress should want that discrimination invalidated. Such statutes are a blow to the economic union of 50 states. They undermine our federal system. To put it bluntly, Mr. Chairman, the rule against economic non-discrimination among states prevents what our founders envisioned, interstate trade wars. And to conclude, H.R. 5034 gives states free rein to pass intentionally and facially discriminatory statutes that foreclose out-of-state wholesalers and retailers from market access. If passed, the bill would exempt specific types of wine businesses from Commerce Clause protection. This is virtually unprecedented in the law. Today, state-regulated, robustly regulated interstate wine shipping is available in 37 states and the District of Columbia. These permits in the states that allow direct shipping require ID checks, they require licensing, they require that the wine sellers submit to the jurisdiction of the state, they require strict reporting requirements, and if a winery or retailer runs afoul of one of these laws under the 21st Amendment Enforcement Act, a state attorney general can take them into federal court. There is more and clearer regulation of wine than ever before. Simply put, H.R. 5034 is a drastic solution to a problem that does not exist. In its original or amended form, it is a transparent attempt to maintain a lucrative anomaly for a few by eviscerating the Commerce Clause. And finally, my last point, as the Bacchus Court put it, as Justice White so eloquently stated, if we abandon the Commerce Clause in this way, the trade and business of our country would be at the mercy of local regulations, having for their object to secure exclusive benefits to citizens and products of particular states. This committee should decisively reject H.R. 5034.
Very persuasive. Michelle Simon is Research and Policy Director of the Marin Institute, has a master's in public health from Yale School of Medicine and a law degree from Hastings College of Law. and has worked extensively on the prevention of alcohol-related public health concerns. Welcome.
Thank you very much, Chairman Conyers, and to the members of the committee for the opportunity to testify today in support of H.R. 5034. I am a public health lawyer and the Research and Policy Director at Marin Institute, a nonprofit whose mission is to protect the public from alcohol-related harm. While the discourse of this bill has pitted different sectors of the alcohol industry against each other, that fight is irrelevant to us. Our only interest is what is in the best interest for the public's health and safety. Indeed, Marin Institute often disagrees with the industry proponents of this bill on other policy matters, and will likely continue to do so. Our goal is to advance prevention policies to reduce the tremendous harm caused by alcohol consumption. Far from being a benign substance, alcohol use causes a wide variety of harm, even when consumed at what the federal government defines as moderate levels. In the United States today, alcohol remains the third leading cause of preventable death. At least 85,000 deaths are attributable to alcohol consumption each year. Also, the economic costs of alcohol were estimated to have been $220 billion in 2005. Much of that cost is from lost productivity, meaning that businesses and our economy also suffer greatly. And while my organization is based in California, Marin Institute has always been a national leader, and we work closely with policymakers and public health advocates at the state and local levels throughout the nation. I can attest to the critical role that state regulation of alcohol plays in giving policymakers and advocates the tools they need to protect the public. Indeed, I just returned speaking from Wisconsin and Massachusetts, where state and local lawmakers, along with public health advocates, were gathered to learn how they can help advance effective prevention policies to reduce alcohol harm in their communities. At both events, it was well understood that states have the authority to regulate alcohol. And yet this authority, which has largely been taken for granted, is increasingly coming under attack by those who want to see federal law trump well-established state authority. The current state-based system of alcohol regulation has been in place for a long time because, for the most part, it works well. Moreover, due to the severity of alcohol problems throughout our country, numerous federal agencies work to assist states in addressing alcohol-related prevention, treatment, law enforcement, and research. Therefore, the CARE Act would go a long way to help ensure that such federal programs are not undermined by current legal threats to state-based regulation. I want to share 3 specific examples of state regulation to protect the public's interest through prevention. The first is access to alcohol. The research is abundantly clear that the more access people have, especially youth, to alcohol, the greater the number of problems communities will experience. By controlling where and when alcohol is sold, states can seek to prevent those problems associated with increased availability. And states are in the best position to evaluate and address problems facing their communities and restrict access when and where it is needed. Another area where states need to be able to regulate is pricing. For example, policies that prohibit volume discounts make good sense from a public health perspective. Substantial research shows that higher alcohol prices are associated with reduced alcohol consumption, especially in youth. Marin Institute is very concerned about legal challenges of pricing policies by certain chain stores in the retail sector. Cheap prices for consumers should not be the only consideration. In fact, such concerns should be secondary to public health and safety. A third important aspect of state regulation is the 3-tier system. Requiring that alcohol be sold from producers to distributors and then to retailers has proven to be a necessary policy for protecting the health and safety of the public. The 3-tier system helps to ensure that the state has adequate oversight of alcohol sales, helping to prevent aggressive marketing and sales tactics. Although how to best regulate alcohol might seem like any other rhetorical debate over balancing the interests of private industry with government, there is an important difference. Diminished state authority will most certainly result in more lives lost, higher costs, and more families forever changed by alcohol consumption. Odds are that most people in this room know someone who has been negatively impacted by alcohol use. Make no mistake, this is not a rhetorical debate. This is about saving lives. For decades, alcohol has been recognized as being different because it is. The cornerstone of that recognition is the state's authority under the 21st Amendment to regulate the sale of alcohol to ensure an orderly marketplace. I urge the committee to strengthen the regulatory authority of states to ensure that the public health and safety of the American people remain the top priority, and to continue to seek additional ways to support state-level efforts to reduce alcohol harm. Thank you very much.
Thank you, Ms. Simon. Before I yield to Lamar Smith, I'd like to ask anyone, starting with our first witness, if anything that was said here would lead you to want to remark about it by your fellow panelists, or any other final thoughts you might have about the subject matter that brings us here today. Mr. Attorney General.
Thank you, Mr. Chairman. You know, the only thing that strikes me is that there's all this, obviously the Commerce Clause. I support and love the Constitution, the Founding Fathers. 21st Amendment was an extraordinary time in our history where for over a decade we saw mostly failed federal policy and what it did tear apart this country. It was a well-reasoned, well-thought out, it was current, it was dealing with the problem, it was taken back to the states, and it gave back to the states what traditionally was theirs, and that is the regulation of alcohol. It's a unique product, it was a unique amendment, it's just as important part of the Constitution as the Commerce Clause, as any other part of that Constitution, and that's why this is so unique. No other laws, no other Constitution dealt with any other products and services in this country, but this is different, it's unique, and we all know why. It's been spoken very clearly, the effects, the negative effects that alcohol can have on our society, particularly our youth. And so would remind you that this is particularly unique. It is the 21st Amendment, but the courts have now made it clear that you have you as Congress have control in defining the extent of the Dormant Commerce Clause, and that's why we're coming back to you to ask for your help.
The enforcer from Michigan, what have you to say?
I like that title. Thank you, Mr. Chairman.
Regulator, perhaps. Okay.
I just want to comment on what Professor Elhaeg had indicated about these lawsuits. None of these lawsuits have led to deregulation. Should we wait till the bottom falls out for us to act? Every lawsuit chips away at our ability to regulate this highly regulated product. Every single lawsuit. Of the 20 lawsuits that have existed, one state or another had to act in one way or the other to comply with what happened in regards to that lawsuit. And what happens when Michigan gets sued with Siesta Village and we lose that lawsuit, but then two neighboring states, Texas and New York, the same identical issues and lawsuits, get that lawsuit, and, well, they're not neighboring in that sense, but the results are exactly the opposite. So when the Utah Attorney General says, what am I supposed to tell my regulators or other states? Who do you follow? Are you extra cautious because Michigan lost? Or do you follow the New York model? Do you follow the Texas model? That's why Congress really needs to come in here. The fact that none of these have led to deregulation, they have absolutely led to every regulator in that state to make some kind of change, or that legislature to comply with that lawsuit. So this is a public interest issue. This is public interest versus the private sector. This is money versus protecting the health, safety, and welfare of the general public, of the citizens of the state of Michigan, or any other state. That's the bottom line here, what we're talking about. All these projections about if Zinfandel is not made by New York, but New York discriminates, why in the world would the state of New York discriminate against a product they don't make when they can make money for their state? This is a multi-million-dollar business for all of us in one form or another. But as the regulator, I don't just carry the money that I bring to the state. I carry the responsibility that it comes with. And that never goes away. Thank you.
I wonder what he does tell them.
Spend more taxpayers' dollars litigating the question, more money spent, taxpayers' dollars that could be going to educational programs like our parentsempowered.org, where we're giving information to parents in order to provide more information to their kids. That's the problem.
Mr. Doyle?
When I hear calls for Congress to back away from states' regulatory authority and to provide them with even more primacy, I think about the important role that Congress has played and the federal government has played, and I also stated that I don't want the federal government to back away. I want to point out some of the important things the federal government roles played in alcohol regulation and things like underage drinking. As a 19-year-old in 1979, it's certainly emblazoned on my mind what an important role the federal government had in passing effectively 21-year-old drinking age nationally. And without that role, that certainly wouldn't have happened as quickly and may not have happened at all, but everyone can conjecture. The .08 national blood alcohol level effectively was also something that the federal government had a lot to do with. So I think there is a federal role. It isn't to say that states don't have primary role, but I just want to remind everyone that it isn't all bad what the federal government does, and in this realm in particular, and that people like me look for protection. So, thank you.
Did you feel that way when you were 19 and the law
No,
kicked in?
but I'll tell you, sir, I registered to vote and I voted the next time around. Not for the guy who didn't. Well, whatever. You know what I'm saying.
Well, I think I get your drift, but
At the time, I wasn't in favor of it. Let's put it that way.
Professor Diamond.
Yes, thank you. I'd like to make 3 points. First, we've been told that there's a problem because there will be no longer a possibility to bring a case purely for discriminatory effects. Donald Regan, a professor at the University of Michigan, wrote a very long article in 1986 in which he showed that there's never been, up to that point, and I believe it's still the case, a Supreme Court case in which the Dormant Commerce Clause was used to reject a state law in the absence of either intentional or facial discrimination. Indeed, if you look at how the Supreme Court is beginning to describe Dormant Commerce Clause jurisprudence, in United Haulers and in Kentucky versus Davis, 2 recent cases, they no longer go through what they used to, the old-fashioned incantatory repetition of 3 kinds of discrimination: facial, intentional, and effectual. They do not mention effectual anymore. We've been told that there's a problem. As a matter of fact, this doesn't mean that discriminatory effects will become irrelevant. They will be very important as evidence on the question of whether there's intentional discrimination. We're told that that won't work because, as in Bacchus, the state of Hawaii denied that they were trying to intentionally discriminate. Well, the important point about Bacchus is the United States Supreme Court didn't believe them. Secondly, we were told that price affirmation, the striking down of price affirmation would now be in jeopardy. This is simply false. And it's not false because it could be false on the grounds that Brown-Forman was a case of extraterritorial regulation, which does not really depend on the Commerce Clause. But more importantly, in the subsequent case, Healy, the court said that price affirmation, both prospective, simultaneous, and retrospective, constituted facial discrimination. That would still be invalid. And thirdly, we've been given several tone poems about the importance of the national union, and I certainly share those. But we are not a single market system. We are a federal system, and I can't quote it, unfortunately, I didn't bring it with me, but I'd like to refer to another tone poem from a famous Harvard professor, Henry Hart, in the 1950s, who said, "It is only the fact that we are a federal system where states still get to make laws that distinguishes us from Soviet totalitarianism." Thank you.
Professor Elhague.
Thank you. So one statement I'd like to respond to is the claim not only that the amount of litigation has been excessive, but that it's increasing. Now, I don't know exactly what the normative standard is for whether 20 to 30 cases is excessive or not. It's less in some other areas. But the one thing that's clear to me is that the rate is declining. There's far fewer cases now than before. So that if this is really the concern, it's just too late. It might have been a good reason a few years ago. It's not a good reason now for legislation. Second, the claim was made that they haven't resulted in deregulation yet, but the cases might. I don't think any of the cases posed any serious threat of general deregulation. The language is quite clear that about the 21st Amendment powers of the states. They can ban alcohol They can impose any tax they want to raise alcohol. They can take over the sale of alcohol, and they can have a three-tier system and require, I think, in-state residence for retailers, crucially. Now, Ms. Simone, I think, I have some sympathy with because she suffered from the Siesta Village District Court case, which I think was wrongly decided. It was mooted on appeal, and actually there's not just two, but there's 3 appellate courts that since have come out the other way. So I think the law is actually now fairly clear that in-state residency requirements for retailers are fine because it's inherent to finding who the retailer is in the 3-tier process. But if that's really a concern, and there are 2 areas where I identify small technical conflicts that I think are largely moot, but Congress could act. One of those is that area, but that would require simply a statute that said the Dormant Commerce Clause should not be construed to invalidate in-state residency requirements for retailers, not this much broader statute. The claim was also made that the discriminatory effects test has never been used independently of intent. I mean, certainly the courts have articulated it as separately. There is some controversy on this issue, I think mainly because there's ambiguity about what intent means. Is intent subjective intent, or is it an objective intent that we infer from effects? Sometimes commentators think that really in all cases where courts are talking about effects, they're saying, well, we infer the objective intent to do what you have actually had the effects of. That actually creates a new ambiguity, a problem with this statute, because right now that's not a problem because effects or intent suffice. With this statute, the courts would have to deal with this new question of, well, when they tell us we can only go in intent and not effects, are we allowed to infer, the court will ask, the intent from the effects anymore, or are we not allowed to do that? I would anticipate a new round of court splits on that issue if this bill is passed. And then finally, the claim was made that the notion that the price affirmation laws will be sustained under this statute is simply false. The statute does get rid of the direct regulation prong, which is what Brown-Forman relied on. There are some cases that talk about those laws as also being discriminatory, but what they say is they're discriminatory against out-of-state consumers. And the one thing that's clear from this act is it doesn't cover discrimination against consumers.
Attorney Jennison.
Thank you, Mr. Chairman. Just a few quick points. First, I've worked with the wine producer and retailer industry for about 10 years now, and I can tell you 2 things about them. First, they are deeply committed to preventing underage access. We all have children. We're all concerned that state alcohol regulations are in place and they're effective. And second, they have both been deeply committed to working with state legislatures. The first effort is always, can we work something out at the state legislative level for a balanced, even-handed regulation? And if, at the last resort, we have to go to litigation in those states that stubbornly insist on discrimination, then we go to court. And I have to respectfully disagree with Professor Elhag on the issue of wine retailers being allowed limited regulated market access into states. The only case that I've brought has to do with the state of Texas, where in-state wine retailers are given the authority to, by statute, to remotely sell and ship wine to Texas consumers. An Arkansas wine retailer on the other side of the border cannot do that, precluded from being able to do that. The Commerce Clause protects articles, wine in interstate commerce. Producers are selling wine, wine retailers are selling wine. If the state of Texas wants to put very intense regulatory teeth into a even-handed wine retailers bill, we are all for that. But to preclude wine retailers from selling wine across state borders violates the Commerce Clause.
Ms. Simon.
Thank you. Just 2 quick points. One, I think just to take a step back and look at the bigger picture in response to the minimization we're hearing about the litigation and how many lawsuits there are. And of course, many of these lawsuits are working their way up to higher levels, so that means they will have even broader impact in those jurisdictions. But it's important to remember that litigation is really just one strategy being waged in what I think of as a larger march towards deregulation by many sectors, very different quarters of this industry, frankly, and this is something that we're very concerned about at Marin Institute we just did a whole report about the efforts to privatize and control states. I know that's not what we're discussing here, but it is relevant to the company Costco, which has brought litigation in the state of Washington and is currently funding an initiative there to privatize the system. And so, you know, litigation is one, these companies will use any tools at their disposal, and what we're asking for here is for Congress to help limit this one particular strategy of litigation, while of course they will continue to use other forms to get the deregulation that they ultimately want. Second quick point is this idea of the baseball analogy that was made about the away team versus the home team. There's a reason, it's not about discrimination, that we make sure that licensees have a local presence in states, and that has to do with accountability. And that brings me to the point that it's important to remember that while we're hearing a lot about small producers, most of the alcohol sold in this country is in fact manufactured by foreign multinational companies. So Anheuser-Busch was taken over by a Belgian-based company, InBev. Miller Coors is a joint venture owned by 2 foreign companies. The wine industry, we did a whole report in California about the wine industry there, which is increasingly, these so-called small family wineries are increasingly being bought out by multinational companies that are certainly not based in California, and in some cases not even based in the US. So the point is, we need state-based regulation to require local presence, because we can't get at it as this industry becomes more and more consolidated, more and more globalized. It's critical to be able to regulate as much as we can at the local level, and not just retailers, but wholesalers sort of are our last gasp at maintaining a local accountability over this industry. Thank you.
Well, I thank you all and recognize my friend Lamar Smith.
Thank you, Mr. Chairman. Professor Diamond and Professor Alhaig, is that correct?
Elhaig, yes.
Elhaig. Let me go back to the question of the scope or extent of the problem, particularly in regard to lawsuits. Could you give us an idea of how many lawsuits are pending and how they compare, say, to the historical average, so that we can put them in perspective? Professor Alhaig, yes. Professor Diamond.
There have been 3 times since repeal when there have been bursts of litigation, I think. One was in the 1930s, at the time when the Supreme Court finally and clearly said that the 21st Amendment protected state law. The second was in the 70s and 80s, when there was a series of challenges to state laws claiming that they were preempted by the Sherman Act. And the recent one was in the last 7 years, starting before Granholm and including Granholm. And I want to second what Michelle Simon said. It's not a matter simply of counting of counting lawsuits. It's a matter of people saying that what they want to do is to be able to sell beer, for instance, like they could sell potato chips. It's a matter of a general sense that this, which has been referred to by many people, that Prohibition was a long time ago. Alcohol really isn't so different. Why can't we just treat it like anything else? It's a view which is reflected when the FTC sometimes talks as if the only issue with alcohol is the price as low as possible and is the availability as wide as possible. But whereas we all know that's not the point with alcohol.
Thank you, Professor Diamond. Professor Alhaig, do you have anything to add to that?
Yes, just in terms of an actual count of cases now, the count has varied for different people, but I think in the mid-20s is overall since Granholm. But in the last 12 to 18 months, there's only been 3 filed, so that's a declining rate. One of them was dismissed. One of them had facial discrimination. They ruled in favor of the plaintiff, and one of them is still awaiting actual substantive resolution. There are 5 other sort of cases that, 2 which are resolved on appeal. There's issues like attorney's fees still, but there are other cases, and 3 cases that are on appeal that were in trial. But in terms of actual active trial litigation, there seems to be only 1 right now, and the new filing rate does not suggest an increasing rate.
Yes, sir. Thank you. Next question, Professor Diamond and Ms. Janissen. The revised legislation says that states cannot discriminate against out-of-state producers. Are there any examples of that occurring now?
Well, there's a lawsuit in Illinois.
Except for, yes.
So losses,
Right.
I'm not aware.
Anything, Ms. Janessen?
Yes, Mr. Smith, there are still laws on the books that require an initial visit by a consumer to a winery. Before that, consumer can then purchase wine. So if you live in Oregon, say, Indiana's going to require that as a consumer, you fly all the way out to Indiana in order to purchase the wine, and then you may be able to purchase it over the internet. So that is still on the books. There are several states that still have production caps in place, and these production caps, they discriminate against wineries by the amount they produce every year. And that bears no relationship to any activity that they're doing in the concerned state. And so they let their own wineries ship. They usually set the gallonage cap at the highest winery in their own state.
Okay.
And then they preclude others.
Right. Mr. Chairman, I'd like to sneak in one more question, and this would be for you, Ms. Janessen, Professor Elhaeg, and Mr. Doyle. Just very quickly, what suggestions do you have for improving the pending legislation? And Ms. Janessen, if you want to start.
Yes, thank you again, Mr. Smith. We really do have in place a very, very sound, workable framework for analyzing these cases, which really strikes the appropriate balance between robust 21st Amendment regulation, which is still intact, alive and well, and entry for wineries and retailers.
Thanks. Professor Elhaeg?
I would say, one, eliminate Section 3A, because right now it either means nothing or it means something quite unclear and ambiguous. And usually if the best thing you can say for a section is maybe it means nothing, we should get rid of it, I think.
Okay.
Then with Section 3B, I just think it needs to be drastically narrowed or eliminated. As far as I can tell, the main concern that's come out of this hearing is really protecting children, having ID checks. Again, I think the law is allowing in-person sales requirements and in-residency requirements, but those two things could be clarified. So Congress could say, without having this broad permission of discrimination, simply say states are allowed to require an ID check, in-person sales if they want, or in-state residency requirements for retailers.
Okay. Thank you, and Mr. Doyle.
I think there's a lot of things that small brewers would like to see help with. But if you look at my testimony, the two things that I speak about are labeling laws that might discriminate. So federal labeling requirements that trump state labeling requirements would be something. And we also talked about state franchise laws, which are used to, dictate the terms of trade with small brewers, and that's not really what the laws were made for. So state franchise law, federal franchise law exemption for small brewers would be something else that would help.
Those are helpful answers. I thank you, Mr. Chairman. Thank you.
Gentleman from New York, Mr. Dan Maffei.
Mr. Chairman, I thank you, and I thank the witnesses for being here. This is a very interesting debate. It seems that there is some agreement on the panel that the current three-tiered system does work, and that the key thing is to maintain it. It's very interesting. I've never heard quite such a spirited debate on how to best maintain the status quo, with half the panel saying that the best way to maintain the status quo is to pass this new law, and the other half saying, oh gosh, we don't want to do that. So, but it is very interesting. Also, it seems the crux of this is whether anti-discriminatory practices would be hurt or helped by the new law. So I guess I'll start by, and I don't have a lot of time, so I can't ask everybody, but Mr. Doyle, since you are an actual practitioner, what is your fear in terms of how this would encourage states to pass anti-discriminatory laws that would say discriminate against your product, and to the extent that you can be specific, I'd ask you to be specific about what is your fear?
What am I worried about?
Yeah.
Well, I mean, again, I talked about franchise laws, I talked about labeling laws, I gave you some examples of a couple of states.
But if that's already happening and you can challenge them in court now, but you think if this law were passed, you wouldn't be allowed to do that?
Yeah, I think that's, in fact, part of the reason for the law. And the other thing would be differential taxation rates. That's something else that we would be concerned about. Those are three examples.
Professor Diamond, do you think the CARE Act would lead to those issues? And if not, how do you think it would prevent those sort of things from happening?
First of all, as far as labeling goes, states have control now to pass any labeling laws they want. The federal labeling statutes are not preemptive. The only federal labeling statute that claims preemption is the health warning label that was passed when in the 1980s or much, much later, and that's actually never been litigated to see if the 21st Amendment has any relation to that. But federal labeling law does not trump state law. In the I can just refer you to the Bronco case, among others. Differential treatment of taxation. Federal government does it, states do it. The question is, we can envisage schemes in which something might be done, and we're quite confident is only being done in order to hurt outside people and to the benefit of inside people. If that's the case, it would be vulnerable. Otherwise, not.
Do you think do you think the CARE Act would promote more of this, or?
I think the CARE Act would help prevent continued erosion. Judge Calabresi in the Second Circuit, in the case in which they upheld the state law insisting on physical presence for retailers, in effect intimated that the Supreme Court is beginning to has been limiting the scope of the 21st Amendment in what he delicately suggested was not particularly a principled way. And while you can't change what the Supreme Court does, and neither can a circuit court of the United States, you can, in Congress, under your Commerce Clause powers, make clear that you still wish to support state laws. I might just say that the language about primary responsibility being in the state is language which, as in the sense of Congress, was mentioned not so many years ago in the Stop Act. But more importantly, in the 1930s, Congress repealed the Reed Amendment, which was passed in 1917. The Reed Amendment said that if a state banned the sale of alcoholic beverages, the Congress then said it was illegal to ship alcoholic beverages into that state. This was passed because this was proposed by Senator Reed, the senator from Missouri who was known then as the senator from Anheuser-Busch, because he was hoping to embarrass the Anti-Saloon League because he thought that they wouldn't want to make states decide that if they banned sale within the state, they couldn't let people buy from other states. The Anti-Saloon League took them up on the bet. The important point is, in the 1930s, Congress said we were repealing this because it is inappropriate for us to be attaching conditions to how states regulate. I think that shows a congressional recognition of primary responsibility being in the states.
Thank you, Professor Diamond. I do want to ask Ms. Jennison one question. We've been talking about preferences, and you mentioned wine from other places. It does seem to me that that there might be some valid reason to have some preference for local content or local control, particularly when it comes to alcohol consumption. Now, I say this as somebody who has local beer wholesalers who are family businesses that go back generations and employ hundreds of people, but also local wineries in upstate New York and the Finger Lakes. I have small craft breweries, and I have an Anheuser-Busch brewery locally. So on this issue, by the way, you might note that there's a hard place here and a rock here, and I'm caught between them. But I do want to ask you, is there any, I mean, some of the internet example you use, I mean, is there any reason why you would want to have some sort of bias towards local, or somebody who, as opposed to being able to order wine from across the country, even across the world?
Well, interestingly, thank you for the question. And interestingly, the in-state wine industries across the country, including places like Massachusetts and New York, have welcomed these even-handed bills and laws. They feel that their in-state legislatures help them in other ways by promoting their industry, that they don't need to be shielded from competition, because what they'd like to do is they'd like to ship wine all over the country in a regulated way too. And so if each state starts protecting its own wineries, then nobody can ship anywhere. And so our work with the in-state wine industries around the country has been very valuable to demonstrate to us that they are very open to competition. And in fact, a lot of their wines are award-winning wines, and they feel like they can compete on the same shelves and with the same consumers as, say, California wines. With respect to alcohol consumption, which was the other part of your question, we are very much in agreement that states ought to engage in robust alcohol regulation regarding consumption, and that each state should be able to do that with ID checks, sting operations, whatever it takes to control the local underage access problems. But just as far as insulating states from competition, our experience is that wineries welcome it, and they really are ready to compete.
Ms. Simon, I'm out of time, but you look a little skeptical.
Sorry, hard to hide that. So we are opposed to internet shipping. And the reason for that is concerns over, youth don't need any more ways to get access to alcohol. And this idea of requiring, IDs, I mean, there are a lot of problems with third-party ID checks. We can't expect FedEx to be checking IDs when these, bottles get delivered to who knows where. So, it's disingenuous to me to separate, saying that we really want support states to control youth access, but we don't want, this word discrimination, I think, is being tossed around a little too freely when these aren't mutually exclusive. This idea of giving states the ability to control access and yet, opening up state borders to be able to ship wine all over the country. And, wine isn't a benign product either. I think the wine industry likes to kind of think of wine as not benign, and it's 14% alcohol in most cases. So, and also we're very concerned about opening the floodgates. So if you let wine be shipped all over the country, what's next? And so to me, it's really about restricting as much as, reasonably feasible access to alcohol.
Thank you, Ms. Jensen. I think you made your point very well, and I do want to thank the chair and the ranking member for their indulgence.
Senior member of the committee from Virginia, Bob Goodlatte.
Thank you, Mr. Chairman. I appreciate your holding this hearing, and I appreciate the testimony of all the witnesses. It's been very, very interesting. I believe that the 21st Amendment gives the state special authority to regulate the importation and transportation of alcohol within its borders. And thus, I'm naturally inclined to give great deference to state laws regulating alcohol. However, when H.R. 5034 was originally introduced, I had concerns that the legislation went too far. I thought the language was too broad and could be read to pave the way for allowing states to pass facially discriminatory laws that went beyond the ruling in the Granholm decision, and I thought it was unnecessarily stifled the enforcement of antitrust law. However, I'm very pleased with the changes in the proposed manager's amendment. I believe that these changes go a long way towards striking the right balance between the strong right of states to regulate the sale and importation of alcohol in the interest of out-of-state businesses seeking to sell product in the state. While I still have some concerns, and will continue to work with the beer producers and the wine producers, some of whom are in my congressional district in Virginia, I think that we can work on those as we move forward. I also think that the number one concern that we should have is the same concern that this Congress had when it passed the 21st Amendment back in the 1930s, and that is to make sure that we are doing everything we can to protect this unique product from being abused. And therefore, I think the states should be entrusted first and foremost with that authority, and any changes that we make in the law should be geared toward making sure that we are keeping alcohol out of the hands of children and are allowing the states the maximum authority that they need to make sure it's properly regulated. So, nonetheless, I've heard some complaints from various sources about ways that this law could be burdensome upon beer producers and wine producers. So I'd like to ask Mr. Doyle, one of the concerns I've heard is that the state of New York has a desire to require state-specific labels, UPC labels, on all bottles entering the state. I think that's because they have a deposit on their bottles, and so if you don't have some kind of identifying indication and you buy beer and wine or something like that in Pennsylvania and they don't know that it was not purchased in New York, they take it across the line, they get reimbursed for all these bottles. And so proposals have been made to impose some pretty severe restrictions on out-of-state producers. And opponents of H.R. 5034 say that the current Delahunt draft would give states the ability to enact such laws. And I'm wondering if you believe that the amended language would still allow a law such as the proposal in New York requiring state-specific UPC codes to move forward. And then I'll see if anybody else wants to comment on that too.
Well, as you know, I'm a business person. I'm not an attorney, but the attorneys that I've spoken to have told me that, yes, that is a concern.
And I know that the water bottling industry, it's either through legislation in New York or through a lawsuit, been able to argue under the Interstate Commerce Clause that that's an unfair burden on interstate commerce to require out-of-state bottlers of water to put these special UPC codes on. And so they're exempt from the law. And I'm wondering, since this is not an issue that relates to the actual regulation of alcohol, actually we're talking here about the empty containers afterwards, isn't there some easy solution to this problem that would make it clear that the law simply doesn't cover the containers that might be shipped from out of state?
Well, in 5 minutes, I had a couple of examples, and that was a very, very recent one. But I'll give you an example. Professor Diamond was talking about government warning labels and the fact that there's no statutory reason why the federal government warning label would trump state government warning labels. We now have a situation where the various localities have asked retailers to put calorie counts and other nutritional information for each particular city or town you might be in. My concern would be something like this. You could have 50 government warning labels necessary or 25 in 25 different states.
My time is running short. And we gotta vote. I'm going to turn to Professor Diamond because he's shaking his head and doesn't agree with that.
I think I was misunderstood. I said that the federal warning label is the only act of federal regulation involving alcoholic beverages which specifically claims to preempt state laws. The laws involving the labeling regulations in the original FAA do not.
May I jump in on that,
Sure,
please?
yes.
Because labeling is an issue that states have an absolute right to control at this point because the federal government is silent and has given states that authority and power to do that. In fact, in Michigan, just a few weeks ago, we took a motion to reconsider labels of these alcohol energy drinks that are...
But let me interfere. We're not talking about the content of the bottle. We're talking about the bottle itself here. So what I'm asking you is, because I'm supportive of the effort to protect the state's rights under the 21st Amendment,
Yes, sir.
can't we find a way to take off the table an issue like whether or not a state would discriminate between a bottle that's used to put alcohol in it and a bottle that's used to put water in it as to the recycling process that state wants to enact for recycling? That seems to be the issue here that we need to find a way to resolve.
I think that may be an issue in Mr. Doyle's state. It isn't an issue in our state. I think there's a number of factors that come along with that. It's the green initiative, it's the recycling initiative, it's a control mechanism. Michigan has Wisconsin as a border state. Wisconsin's return laws are only 5 cents a can. Some of them don't even have a return law.
I understand the problem. It just seems to me that in the context of this legislation, that issue could be, and we probably ought to focus moving forward to make sure that issue is off the table on this. And let me ask one other question. Under the Delahunt Amendment to H.R. 5034, would a state be able to enact a law that is facially neutral, but in effect discriminates against out-of-state producers? And I'll start with you, Professor Diamond, then we'll go to Professor Elhage.
Yes, if it is deemed to be intentionally discriminatory.
Have you got that turned on here?
I'm sorry.
Yeah, that's better.
Yes, if it is deemed to be intentionally discriminatory. Professor Elhage, in his written testimony, said that that's unlikely to occur because courts are reluctant to tell legislatures that they've been indeed just playing cute and being artful. I don't happen to agree that's the case, and if it is the case, I would suggest that maybe courts should do that and not overly intrude on the legislative process by claiming that they find discriminatory effects. Discriminatory effects is a very problematic issue in the academic literature because it so easily, as Lisa Heinzerling and others have pointed out, turns into abusive and Lochner-like supervision of legislative decisions by the courts. They could simply, if they believe, and as Professor Regan says, judges decide questions of motive all the time, if they believe that this was done for the purpose of discriminating against.
Got to give it to him because time's of the essence here.
So what I think courts are reluctant to look at the subjective motive of legislators. There is this complicated question I alluded to earlier, whether effects test really differs from looking at objective intent that one infers from the effects. But I do think if a court does not find intent, this statute clearly would allow laws that have discriminatory effects, and that is in fact harmful, because part of the point of the Dormant Commerce Clause is also to police state laws that are indifferent to the harms that they cause out of state. So an ideal political process is politically accountable to everybody who's benefited and harmed by what they do. And if it's non-discriminatory, they weigh those benefits and harms well in the political process. But if many of the harms are on outsiders, out-of-staters, because of discriminatory effects and all the benefits are in-state, even if they don't care about the external effects, it still distorts the political process. So I think, when I think about the issue, I think, well, how would we feel if China passed a law that discriminated against U.S. producers and said, it's fine because we didn't really care about the U.S. producers. We're not trying to harm them. We just don't take them into account. Well, I think we'd still have just as big a problem with that. And the fact that they're only accountable to domestic interests is what would cause that, whether or not they're intentionally thinking about harming out-of-staters.
May I jump in here, please?
That's up to the chairman. My time's expired, and Ms. Jensen wants to comment too.
Mr. Chairman, may I ask the chair a question? I've been here all day since you have, since the rooster crowed. Do we still have time to put questions to the panel?
Yeah, Mr. Chairman.
We're going to have everyone here. The time will be divided evenly between the last three members of the panel, and then all other questions will be submitted.
Should come back. I can come back, Mr. Chairman, if you want us to.
No, well, I want you to, but the other seven don't want you to. So let's just divide it up. I mean, and Rick Boucher is very, let me recognize Ms. Jennison and then Rick Boucher, Subcommittee Chair in Energy and Labor.
This bill, a statute like existed in Massachusetts, which the effect of which was to prevent 98% of interstate commerce in wine from Massachusetts market access. That was the effect. That kind of statute would be immunized from challenge if the amended version were to pass.
Chairman Boucher.
Well, Mr. Conyers, thank you very much. I appreciate your having this hearing today. I'm going to be very brief. Professor Elhage, and I'm sorry if I've mispronounced your name, I am viewing this through the lens of what is in the consumer interest. And I would like to have your commentary on whether, if the bill as amended by the manager's amendment becomes law, that would advance or harm the consumer interest. Would it limit choice? Would it raise prices? How would the consumer be affected?
Thank you. I think it's likely to harm consumer interests. 3A is a bit of a wild card. I think the most likely reading is it has no effect, but precisely because it seems to have no, I don't have this on yet, precisely because it seems to have no meaning, there's a lot of court interpretation doctrines are likely to interpret it to inversely preempt some unclear set of federal statutes, one of which might well be the federal antitrust laws, and that would be very harmful to consumers. In addition, because it will allow various forms of laws that, it'll allow in particular laws that are even intentionally or facially discriminatory against out-of-state consumers, that'll clearly be harmful.
Out-of-state shippers.
What's that?
You said out-of-state consumers. Oh, you mean out-of-state consumers of the product with
Yes.
regard to the state where it's manufactured.
Right, so the state is allowed to discriminate under this statute against anybody who's not a producer. You can discriminate if they're out of state, and that would be a dramatic.
That would limit choice in terms of what is available to the consumer in a given state.
Yes,
And that could raise prices.
and that would, I think,
All
would
right.
likely raise prices.
In keeping with the chairman's suggestion that we be brief, I just have one other question, and Ms. Jennison, let me pose that to you. The legislation has been criticized by some on the basis that it might enable states to provide special preferences to in-state manufactured products or other products that are tied in some way to that state, to the disadvantage of products manufactured in other states and shipped into that state. Would you care to comment on that?
Yes, sir, I definitely.
And could you turn your microphone
Yes,
on?
I think I just need to get closer. Thank you. I would like to comment on that because one great example is discriminatory taxes, like in the Bacchus case, where a state could exempt its own local industry from taxation, but require that taxes be levied on out-of-state products. And that was the case in Bacchus. And if this bill, as amended, were to pass, in my view, it overrules Bacchus. It does not protect the product. So any state could literally put that kind of tax or some kind of unique labeling requirement or a barcode where out-of-state products would be unfairly disadvantaged.
All right, thank you very much. I appreciate your questions. Thank you, Mr. Chairman. I yield back.
And thank you very much. We now turn to Howard Coble, gentleman from North Carolina.
Thank you, Mr. Chairman. I, too, will be brief. Thank the panel for being here. Mr. Chairman, I'm a member in good standing with the Wine Caucus. I hope I still am in good standing. But I was surprised when my small wineries came to me recently and said this bill will jeopardize direct shipping. Professor Diamond, is there any provision in this bill that would jeopardize direct shipping? Because I assured them that was not my intent, nor the intent of the bill.
There's nothing in this bill that would jeopardize direct shipping if a state has it or a state could decide to have it. What this bill does is preserves the physical presence requirement for wholesalers and retailers from Dormant Commerce Clause challenge and does remove a pure effects challenge at the producer level. By the way, the Bacchus case was an intentional discrimination case, and that would have been overturned.
Thank you, Professor. Mr. Doyle, I assume that, well, strike that. Maybe I shouldn't assume. Do you agree with me when I say that gallonage caps benefit small wineries and small breweries?
The gallonage caps?
Yes.
Gallonage caps that allow them to do what, or exempt?
To self-distribute.
Oh, to self-distribute. Well, it depends on what side of the cap you're on, I guess.
Well, in your brewery, have you gained revenue or lost revenue in the last couple of years?
Yeah, I mean, we self-distributed when we had no sales, and we self-distribute 24 years later when we have more sales.
But have
Yes.
you gained?
It
or
has
lost?
certainly helped us tremendously.
That was my conclusion as well. I have more questions, but I'll yield back, Mr. Chairman. Thank you.
Well, that's very generous of you. The chair recognizes Sheila Jackson Lee, the gentlelady from Houston, Texas.
Mr. Chairman, thank you very much, and I thank the witnesses. This is a time that is calling us in different locations. Let me go to you, Professor. I'm going to follow the line of reasoning of my colleague from Virginia, Mr. Professor Elhidge. Let me ask a simple question.
Chairman.
Why is this bill so broad? Why would you view it as being so broad, and could we narrow the bill and still be effective in some of the content that is necessary to provide some remedy. Let me just add to that, could it be more narrowly tailored to deal with the immediate concerns and not interfere with consumer options, which you seem to suggest from the question of the gentleman from Virginia?
Yes, I think it could be. As I say, the big concern that's legitimate, I think, is protecting children from alcohol. And Congress could pass a statute that simply clarifies that the majority of the circuits are right. And we could codify the law, but also in a way that avoids any possible challenge. And what the majority of the circuits say is that in-person sales requirements, in order so that people's IDs can be checked, are in fact
legitimate.
Right. And that could be clarified. That's a small technical issue, but that would be useful, I think. Or to the extent the Congress favors a majority of the rules on in-state residency requirements for retailers, it could codify that. And the theory, I think, of the three-tier system has been there's something important about the personal touch of retailers, that they know who their customers are, more likely to check their ID, can be more closely monitored by the state.
Gentlelady has 1 minute remaining before I'll have to close.
Thank you, Mr. Chairman. Let me just say, and does that mean that we could also prevent online purchases if we found a narrowly tailored approach, which is what one of the concerns is?
Could we?
Online purchases by underage.
Could they ban?
Could we find a way to craft language narrowly to provide protection there?
So to allow it but have more ID checks for online?
No,
sales?
to find a way to prevent the online usage by young people, underage.
Okay. Well, I think Congress would have to pass a law that was about that to guarantee that result, but it could pass a law that simply authorizes the states, as long as they do it in a non-discriminatory
to handle it.
way. Yes.
Yeah, Ms. Jennison, do you believe we can craft a bill more narrowly tailored to address some of the concerns as opposed to the bill we now have?
Honestly, Madam, I do not. I believe that the current system, the current legal framework is working very well, that states enjoy broad powers under the 21st Amendment and are exercising them regularly.
So you're not ready for a compromise and you see problems in this bill and approach?
Yes, ma'am.
But you'd be open to us looking at a narrowly crafted effort?
Depending on what that is.
All right. Thank you, Mr. Chairman. I appreciate it. I yield back.
How timely. The chair thanks the witnesses and congratulates them at the same time and invites them to send in any further discussion that we may not have completed. Just send it into the committee and we'll include it in the record. Thank you again, and the committee stands adjourned.
Thank you.
Thank you.
See you, Stuart.